Hi. In this video, we're going to review some of the rules that we've learned concerning contract interpretation. In going over this material, we considered three subjects: the parole evidence rule as it applies to prior agreements, the parole evidence rule as it applies to the meaning of terms, and the possibility of filling gaps in contracts with implied terms. Let's start by talking about the parole evidence rule as it applies to prior agreements. In going over this material, we learned 5 rules. I've put these rules in the slide to my right. The first rule is really just a definition. An integration is the final written expression of an agreement. An integration is complete if it's intended to be the exclusive statement of the agreement. Otherwise, it's incomplete. The second rule is that a complete integration discharges any terms of a prior agreement that are within its scope. The third rule is that a partial integration discharges any terms of a prior agreement that are inconsistent. And the fourth rule is that some jurisdictions determine whether an integration is complete by looking only within the 4 corners of the writing, while others consider all circumstances of its creation. And the fifth rule is that a court may reform a written contract based on mutual mistake or fraud as to its content. Now those are the rules that we've learned, but how do they play out in the actual litigation of cases? Well, let's consider the typical pattern of argumentation. As in any contracts case, the plaintiff's claim is that the defendant made a promise and didn't keep it. For example, Gianni said that R. Russell Company promised to give him the exclusive right to sell soda pop in the building, and then broke that promise. The defendant's defense is that the alleged promise was discharged under the parole evidence rule because it wasn't included in a subsequent written agreement. So, for example, R. Russell said that the alleged promise that we'd give Gianni the exclusive right to sell soda pop was discharged because it was not in the subsequent written lease that we signed. Now we saw that the plaintiff has 3 replies to this defense. The first reply is that the promise was not discharged because it's outside the scope of the written agreement. That's the argument that Gianni tried. But the court rejected that argument. The court said that a promise that he would have the exclusive right to sell soda pop in the building is something that would normally and naturally have been included in the written lease, therefore was within the scope of the written lease, and was discharged under the parole evidence rule. Second argument that the plaintiff might offer in reply is that the promise was not discharged because the written agreement was only a partial integration and the promise is not inconsistent. That argument was accepted in Masterson v. Sine. The court concluded that a deed was only a partial integration. It was never intended to be the exclusive statement of the parties' rights, and therefore a term limiting the right to repurchase the property to family members, even though it was not included in the deed, was not discharged because it wasn't inconsistent. The third reply is that the written agreement should be reformed to include the promise because we both mistakenly thought the promise was included, or because the defendant fraudulently misled me to think it was included. That argument succeeded in the Bollinger v. Central Penn Quarry case. In the Bollinger case, the written contract did not include a promise that the defendant would cover the construction waste with topsoil. But because both parties had thought that that term was included in the written lease, the court reformed the written lease to include the promise. Accordingly, the parole evidence rule didn't discharge that promise because it was deemed to be in the writing, even though in fact it really was not. The next topic that we talked about was the parole evidence rule as it applies to the meaning of terms. Here we saw 3 rules. First, we saw that courts in some jurisdictions will not consider extrinsic evidence other than evidence of trade usage about the meaning of terms in a written contract if those terms appear to have a plain meaning. Other courts, however, will consider evidence of the meaning of terms. In fact, that is the current rule in the restatement in Section 214C. The second rule is that when the evidence shows that the parties attach different meanings to a term in the contract, if one party knew or should have known the meaning attached to the other party, the meaning attached by the other party will prevail. The third rule is that if neither party's meaning of a term prevails under the previous rule, the term cannot be enforced. Now, how do these rules play out in actual litigation? Well, here the pattern of argumentation is a little more complicated. It really takes place, or could take place, in 3 rounds. The first round is just simply the claim and the defense. The claim here is that, well, the defendant promised to do X, which means Y, and didn't do it, And the defense is, well, X actually means Z, and I did Z, and therefore I'm not in breach. We saw 5 examples of this pattern of argumentation in the Pacific Gas, the Raffles v. Wickleshouse case, the Oswald v. Allen case, and the Fergal-Ament and the Hearst cases. So, for example, in the Fergal-Ament v. B&S International Sales case, the plaintiff said, the defendant promised to deliver chicken, which means broiler chicken, and didn't do it. And the defense was, no, chicken means any chicken, and I did deliver chicken. Or in the Oswald v. Allen case, the defendant promised to sell me her Swiss coins, which means all her Swiss coins, and she didn't do it. And the defense was, no, the term Swiss coins meant only my Swiss coins in my Swiss coin collection, and I did offer to sell you those coins. Now, in many cases, round 1 will be the end of it. The court will simply look at the contract and figure out which is the most reasonable interpretation. In some situations, however, either the plaintiff or the defendant will seek to introduce extrinsic evidence about the meaning of the terms in the contract. For example, the plaintiff or the defendant might say, well, the court should conclude that X has my meaning based on the following extrinsic evidence. In the Fergal-Ament case, Fergal-Ament said, well, the court should conclude that the term chicken means broiler chicken based on this testimony of my expert witnesses. Now, in some cases, the other side will simply seek to introduce additional extrinsic evidence. As in Fergal-Ament, B&S presented its own expert witnesses who testified about the meaning of chicken. In other cases, though, one of the parties will say, no, the court should not consider the other party's proffered extrinsic evidence because the term X has a plain meaning. And we saw an example of that in the Raffles v. Wickleshouse case. The seller in that case said that the court should not consider the buyer's testimony that the buyer thought the term Peerless meant a ship named the Peerless sailing in October because it was plain under the contract that as long as the goods were on a ship called the Peerless, it didn't matter when the ship sailed. The court rejected that argument, but that was the argument that was made. Now, the third round of argumentation comes into effect if the evidence shows that the parties attach different meanings to the contract. In that case, either party or both parties might argue, well, my meaning of the term X should prevail because the other party knew or should have known what I thought X meant. That argument was made in the Fergal-Ament v. B&S International Sales case. In that case, the seller said, well, the buyer should have known that I meant only broiler chicken because we used the term chicken in English, even though the rest of our communications were in German, precisely to convey the idea that we're talking about a special kind of chicken. The court rejected that argument, but if the court had accepted it, well then the plaintiff's meaning would have prevailed. The defendant, however, may present a different argument, which is that if my meaning doesn't prevail, meaning if the plaintiff didn't know or shouldn't have known what I thought the term meant, well then the term has no meaning and can't be enforced because I didn't know and I shouldn't have known what the plaintiff thought the term meant. And that was the argument that was raised in the Raffles v. Wickleshouse, Oswald v. Allen, and Fergal-Ament cases. And in all of those cases it succeeded. In the Raffles v. Wickleshouse case, the court concluded that, well, if it's not the October ship, well then the term Peerless doesn't have any meaning, and therefore there is no contract. There is no agreement on that particular aspect. It cannot be enforced. The last topic that we talked about was filling gaps with implied terms, and here we saw 3 rules. First, contracts may include not only their express terms, but also terms implied in law or terms implied in fact. Second rule is that terms implied in fact are based on the particular circumstance of the contract at issue, while terms implied in law are based on policy considerations. And the third rule is that some terms implied in law, like the duty of good faith, are mandatory and cannot be waived or altered. Other terms implied in law, like the general assignability of contract rights, are merely default rules which the parties may change if they want to. Now, how do these rules play out in the actual litigation of cases? Well, there are really 2 different patterns of argumentation. In some cases, one of the parties wants to argue that there's an implied promise. So, for example, the plaintiff might say, the defendant made an implied promise and didn't keep it, and the defendant's defense would then be, well, I didn't make the implied promise. We saw an example of that in the Dickey v. Philadelphia Minuteman case. Dickey said that the plaintiff made an implied promise to use his business in a way that would maximize gross sales because the rent was based on gross sales. Dickey, however, said that no such promise was made. And the question is, well, was the promise made or not? Here a court has to look at all the circumstances of the case. And what the court found most convincing in that case was that the contract included a separate provision which stated a minimal rental. And the court concluded that it was that provision which would take care of the possibility that there wouldn't be gross sales or not sufficient gross sales, and therefore there was no need to find any additional implied promise to deal with the possibility that the gross sales would not produce enough rent. The key thing, though, is, again, you have to look at the contract and explain why a term should or should not be implied. Now, another place where you might get an implied term is you might have an implied condition. So, for example, the plaintiff might say that the defendant made a promise and didn't keep it. The defendant's defense would be, well, my performance was excused by the non-occurrence of an implied condition. It wasn't stated in the contract, but there was a condition that was implied that had to be satisfied. And the plaintiff's response then might be, well, either that the implied condition doesn't exist, or in the alternative that it was satisfied. And it's this last pattern of argumentation that we're going to be looking at